So, under this particular legislation of Competition Act of 2002, the Competition Commission of India was established. The Competition Act of 2002, it is like a tool which will implement in April 1964. It appointed the Monopolies Enquiry Commission. The Competition Bill 2001 was introduced in the Lok Sabha by the Finance Minister Mr. Arun Jaitley on 6th August 2001. Hi and a warm welcome to you all dear students. I, George Lime, Commerce Faculty, Department of Commerce, Vidhyaashram, First Grade College, the Temple of Excellence, MYSURU. Dear students, today we shall take up Unit 6 of your business laws, that is the Competition Act of 2002. So the last chapter or last unit in the syllabus, okay, for your 6th semester BCom of business laws. So in this first session, let us understand what is the introduction of this particular Competition Act of 2000 and the other related terms. First, let us see the introduction part. It says the Competition Act 2002 was enacted by the Parliament of India and it governs Indian competition law. So, this act, the Competition Act of 2002, it was enacted or established in the Parliament by the Parliament of India and it governs the competition law of India or Indian competition law. And it was replaced. It replaced the hierarchy, that is the Monopolies and Restrictive Trade Practices Act of 1956. So, in short form, we say this as the MRTP Act. MRTP Act. So, this particular Competition Act 2002, it replaced the Monopolies Restrictive Trade Practices Act of 1969. Now, under this legislation, the Competition Commission of India, it was established in order to prevent the activities that have an adverse effect on the competition in India. So, under this particular legislation of Competition Act of 2002, the Competition Commission of India was established, right, in order to prevent the activities that have an adverse effect on the competition of India. So, this act extends all of India except Jammu and Kashmir. So, this particular act, the Competition Act of 2002, it is extending to all of India but living except Jammu and Kashmir. Now, this particular Competition Act of 2002 is a tool to implement and enforce competition policy and in order to prevent and punish the anti-competitive business practices which has been followed by the firms, right? And also unnecessary government interference in the market. Now, this particular competition, the Competition Act of 2002, it is like a tool which will implement and enforce the competition policy and also it tries to prevent or it prevents and punishes the anti-competition business practices which has been followed by the various firms and companies and also the unnecessary government intervention that is into the market. So, this competition law is equally applicable on written as well as an oral agreement. So, this competition laws of 2002 is equally applicable on written as well as the oral agreement. So, arrangements between the enterprises or the persons. Now, this Competition Act of 2002, it was amended by the Competition Amendment Act of 2007 and again by the Competition Amendment Act of 2009. So, two times it has been amended. So, this Competition Act of 2002 was amended by the Competition Act, that is of 2007, and again it was amended in 2009. Now, this act establishes a commission. So, they will establish a commission which is a duty-bound commission, right? And it is been to protect the interest of the free and fair competition. Why this particular commission is being established? What is the purpose or necessity of this particular commission which has been established according to this law or under this particular act, or that is of Competition Act of 2002. That is, in order to protect the interest and to have a free and fair competition, including the process of the competitions, as well as a consequence to protect the interest of the consumers at large. And broadly we say the commission's duty is, what are the duties of this particular commission? First and foremost, to prohibit the agreements or the practices. To prohibit, that is to restrict or prohibit the agreements or the practices that have or likely to have an appreciable adverse effect on competition in the market in India. And that is, it may be the horizontal or the vertical agreements conduct. Second, it says to prohibit the abuse of dominance in the market. That means taking a dominant position and doing the monopolistic selling conditions. Then to prohibit acquisitions, purchasing, mergers, amalgamation, etc. between the enterprises which have or likely to have an appreciable adverse effect on the competition in the markets in India. Next, in addition to all this, this Competition Act, it will engage its enforcement with the help to mutual international support as well as in enforcement of network across the world. Okay, students, now let us see or understand the history of this particular Competition Act of 2002. The Government of India in the year 1964, that is in April 1964, appointed the Monopolies Enquiry Commission under the chairmanship of Justice K.C. Das Gupta. And this person, K.C. Das Gupta, was the judge of a Supreme Court, and he had to inquire into the extent and effect of the concentration of economic powers in the private hands, as well as the prevalences of monopolistic and the restrictive trade practices, which is very important sectors of economic activity other than the agriculture. Now, continuing with the history of this particular Competition Act of 2002, it says to regulate advertising in 1984, the Parliament inserted a chapter on unfair trade practices in the Monopolistic and Restrictive Trade Practices Act of 1969. This Monopolies and Restrictive Trade Practices Commission was constituted in the year 1970. And the Monopolies Restrictive Trade Practices Act of 1969 had its genesis in the Directive Principles of State Policy, which was embodied in the Constitution of India. And this particular act was received the assent from the President of India on 27 December 1969. That is the Monopolies Trade and Restrictive Trade Practices Act. And the Monopolies Restrictive Trade Practices Act was intended, why it was, the main purpose of it is, or intended is to curb the rise of concentration of wealth in the few hands, that is, and monopolistic practices, and also to avoid the monopolistic practices, as well as in order to see that they want to curb means to restrict the wealth in the few hands, that is in the private hands. It was repealed on September 2009, and this act has been succeeded by the present act, that is of Competition Act of 2002. The Competition Bill 2001 was introduced in the Lok Sabha by the Finance Minister Mr. Arun Jaitley on 6th August 2001. So this present Competition Bill 2001 was introduced in the Lok Sabha by the former Finance Minister Mr. Arun Jaitley on 6th August 2001. Now coming to the definition, students, there are different terms here. So we'll understand one by one. Acquisition. Acquisition means directly or indirectly acquiring or purchasing or agreeing to acquire, agreeing to purchase the shares or the voting rights or the assets of any enterprises or a companies, or to take the control over the management of that particular companies or the firms or assets of any enterprises. That is the meaning of acquisition. Again, I'll repeat. Acquisition means directly or indirectly acquiring. Acquiring means purchasing, or agreeing to acquire. That means you are agreeing to purchase what? The shares, the voting rights or the assets of any enterprise, that is of any firm or companies, or to take the control or have the control over that particular management or the assets of that particular any enterprise. Next is cartel. What do you mean by cartel? Cartel means it includes an association of producers. Cartel means it refers to the association of producers, sellers, distributors, traders, or the service providers who, by agreement among themselves, limit the control or attempt to control the production part, the distribution part, or the sale or price of goods or provisions of services. So, cartel includes an association of producers, sellers, distributors, traders, or service providers who, by agreement among themselves, limit control or attempt to control the production, distribution, sale, or price of goods or provision of services. The next part related to dominant position. So what do you mean by a dominant position? Dominant position means the position of the strength which is being enjoyed by an enterprise or a company that is irrelevant to the market, which enables that particular company to operate independently of competitive forces which is prevailing in the market or affects its competitors or consumers in its favor. So dominant position means a position of strength which is being enjoyed by an enterprise in the relevant market, which will enable to operate independently of competitive forces which is prevailing in the market or affects its competitors, consumers in its favor. What is predatory pricing? Predatory pricing means the sale of goods or the provision of services at a price which is below the cost of production of that particular goods or provisions of services, with a view to reduce the competition or to eliminate the competition. So the meaning of or definition of this predatory pricing means predatory pricing is nothing but the sale of goods or the provisions or services at a price which is below the cost of production, right, of that particular goods, services, or provision of services, or with a view to reduce the competition or to eliminate that particular competition itself. The next definition, that is of rule of reason. What do you mean by rule of reason? It is analysis of an activity. It is analyzing of an activity or the work under the challenge on the basis of business justification, competitive intent, then market impact, the impact on competition as on consumers. It is a logic behind the conclusion of any order. So I'll repeat, rule of reason means it may be an analysis of any kind of activity or event under the challenge of the basis of business justification, competition intent, market impact, the impact of competition as well as on the consumers, impact of competition and on consumer. So it is a logic behind what? The conclusion of any order. Now coming to the next important aspect of the topic known as anti-competitive agreements. What do you mean by anti-competitive agreements? See, enterprises, persons or association of any enterprises or persons, including cartels, as I told you what is cartels, shall not enter into an agreement in respect of production, supply, distribution, storage, acquisition or control of goods or provision of services which will cause or likely to cause an appreciable adverse impact on the competition in India. So such kind of agreements would consequently be considered as void agreement. So anti-competitive agreement means it is just the opposite. You are going against that particular agreement which has been in the favor of competition. So anything which you do against, it will become an anti, right? So the agreement which you do against any of the agreement, so it becomes an anti-agreement. So the enterprises, so enterprises means it can be a company or it can be an organization, right? Or persons or association of enterprises or companies of persons, including the cartels, shall not enter into agreements in respect of production. Second is supply, then distribution part, storage, acquisition or control of goods or provisions of the services which will cause or likely to cause an appreciable adverse impact on the competition in India. Now, such kind of agreements, such kind of anti-competitive agreements would consequently be considered as void. Agreements which would be considered to have an appreciable adverse impact would be those agreements like directly or indirectly determine sale or purchase prices. Second, it says limit or control the production, supply, market, technical development, investment or provision of services. Then share the market or the source of production or provision of services by allocation of intra-alia geographical area of market, the nature of goods or number of customers or any other similar way. Then directly or indirectly result in bid rigging or collusive bidding. Now coming to the types of agreements, it says an horizontal agreement is an agreement for cooperation between two or more competing business operating at the same level in the market. So horizontal means same at the same level, both like A and B are doing the same business in the same line, in the same market at the same level. So an horizontal agreement is an agreement for cooperation. So it is the made agreement mainly for cooperation between two or more competitive businesses which is operating at the same level and in the same market. A vertical agreement, on the other side, it says it is agreement between the firms at different levels of supply chain. So vertical agreement is an agreement between the firms. It is at different levels of supply chain. Now, for example, a manufacturer of a consumer electronic goods might have a vertical agreement with the retailer according to which the latter, that is a manufacturer, would promote the products in return for lower prices. So this is about the manufacturer, that is the vertical agreement. I'll repeat the example here. A manufacturer of a consumer electronic goods, okay, is a manufacturer, might have a vertical agreement with the retailer, and according to which, that is the marketer, that is manufacturer or marketer, would promote their products in return for low prices. So A is a manufacturer here. So he is a manufacturer, and in the vertical it says he may be going forward to the retailer where this person is selling the products, or distributing the products of this manufacturer. So here under this particular vertical agreement, manufacturer will concentrate, he will not give the products to him, instead he will do it on its own, that is the promotion work and distribution work he will undertake on instead of the retailer. Now coming to the next important topic, that is about abuse of dominant position. What is this, an abuse of dominant position? Abuse of dominant position means there shall be an abuse of dominant position if the enterprise imposes directly or indirectly unfair or discriminatory conditions that is related to purchase or sale of goods or services, or restricts production or technical development, or create any kind of hindrances or the barriers, right, in order to get entry of new operators to the prejudice of the consumers. So abuse of dominant position means there shall be an abuse of dominant position in case if an enterprise or a company imposes directly or indirectly unfair or discriminatory conditions in purchases or sale of goods or services, or restricts the production itself or the technical development which may take place, or it may create an hindrances or the barriers, that is in entry of new operators to the prejudice of consumers. And the provision relating to the abuse of dominant position requires determination of dominance in the relevant markets. And dominant position surely would enable the enterprises to operate independently or affect competitors by action. Now coming to the next part, combinations. What do you mean by combination? See, an act is designed to regulate the operation of the activities of combination, that is the term which contemplates acquisition, mergers or amalgamations. So combination means combining together all the different various activities. So this act is designed in order to regulate the operation of the activities of various combinations, that is the term which is used here, which contemplates, that is acquisition, mergers as well as amalgamations. Combination that exceeds the threshold limits, it's specified in the, which is specified in the act in terms of assets or turnover, surely which causes or likely to cause an adverse impact on the competition within which the relevant market in India and can be scrutinized by the Commission. So students, these are the important topics which I had explained to you. Let us see important topics, that is the which I have covered today under this particular session. I told you about the introduction part of Competition Act of 2002, which was enacted in the Parliament of India and governs Indian competition law, and it replaces the hierarchy, that is the Monopolist Restrictive Trade Practice Act of 1969, which in short form we call as MRTP Act. Now, under this particular legislation, the Competition Commission of India was established in order to prevent the activities that have an adverse effect on the competition in India. So, this Competition Act of 2000 extends to whole of India except Jammu and Kashmir. And this particular Competition Act of 2002, it is a tool to implement and enforce the competition policy and also to prevent and punish the anti-competitive business practices by the firms and unnecessary government interference in the market. And competition laws is equally applicable on written as well as oral agreements or arrangements between the enterprises or the persons. Now, this Competition Act 2002 was amended by the Competition Act and again by in the year 2009. And this particular act establishes a commission which is duty bound in order to protect the interests of the free and fair competition and the consequences protects the interests of consumers. And the history, coming to the history, it says the government of India in the April 1964 appointed a monopolist inquiry commission under the chairmanship of Justice, that is K.C. Das Gupta, is a judge of the Supreme Court. He was a judge of Supreme Court in order to inquire into the extent and the effect of concentration of economic powers in the private hands, and that is few people, and prevalences of monopolistic and restrictive trade practices, which is very important sectors in the important sectors of economic activity other than agriculture. And it regulates advertising in the year 1984, where Parliament inserted a chapter, that is an unfair trade practices and the Monopolist Restrictive Trade Practices Act in 1969. And the Monopolist MRTPC Commission was constituted in the year 1970. The Monopolist and Restrictive Trade Practices Act 1969 added genesis in the directive principles, state policy embodied in the Constitution of India. And it received assent from the President of India on 27 December 1969. Okay, and this MRTP Act was intended, that is, it was formulated in order to restrict the rise of concentration of the wealth in the few hands or private people, and it repealed on September 2009. And this act has been succeeded by the present Act of Competition Act of 2002. The Competition Bill, before this act could be passed, the Competition Bill in 2001 was introduced in the Lok Sabha by the then Finance Minister Mr. Arun Jaitley, that is on 6th August 2001. The definitions, I told you what is acquisition. It means directly or indirectly acquiring or agreeing to acquire shares, voting rights of any other assets or assets of any enterprise, or to have a control over the management or assets of an enterprise. Cartel means it includes association of the producers, sellers, distributors, traders or service providers who by agreement among themselves limit control in order to attempt to control the production, distribution, sale or price of goods or provision of services. Dominant position, it means the position of the strength enjoyed by an enterprise in the relevant market, which will enable to operate independently on its own of competitive forces which is prevailing in the market, and surely or affect its competitors in the market, competitors or the consumers in its favor. Predatory pricing means the sale of goods or the provision of services at a price which is below the cost of production of the goods or provisions of services with a view to reduce the competition or to eliminate the competition. Rule of reason, I told you what is rule of reason. Then anti-competitive agreements. Types of agreements, we have horizontal. It is an agreement for cooperation between two or more competing business operating at the same level in the market. Whereas vertical agreement is an agreement between the firms at the different levels of supply chain. Abuse of dominant position. Abuse of dominant position if an enterprise imposes directly or indirectly unfair or discriminatory conditions in purchase or sale of goods or services, or restricts the production or technical development create hindrance in entry or new operators to the prejudice of consumers. Combination, it is an act designed to regulate the operation of activities of combinations, that is the term which contemplates that the acquisition, then mergers and amalgamations. So students, these are the important topics under this particular session 1. So we shall see some other some more topics which is related to this particular unit, that is the Competition Act of 2002, in the next coming sessions. So till then, take care, have a nice day. Thank you.